Perfect. Welcome everyone to this evening's event. Thank you all for the pivot with the last minute technical glitch or technical snafu. We're glad you found us at the new link. So we're calling this the Inside Scoop on Malpractice Protection. My name is Lauren Oshman. I'm a partner and financial advisor at Vestia Personal Wealth Advisors. For those of you who don't know, Vestia strives to be a first assist for all things financial for physicians. So this includes things like contract negotiation, retirement planning, innovative tax strategies. We do get into some risk management and some asset protection planning, which does remind me that before we get into things tonight, I do have to give the disclaimer that neither Tim, our guest, nor I are accountants or attorneys, and nothing that's shared tonight is meant to be tax or legal advice. You will need to consult your own tax or legal professionals for that specific advice. Part of what you will hear from Tim, and part of the reason that I'm here, is that a robust malpractice protection strategy does include your own personal asset protection planning, which is very much something that our team of advisors at Vestia can help you with. So if you are interested in discussing your personal financial planning as it relates to asset protection, you can either access our website at vestiaadvisors.com. There's a contact us button there that you can use, or you can send us an email at myteam@vestia.com, and we would be happy to talk with you. Tonight, our guest is Tim Bone, who is a 45-year veteran of the medical malpractice protection industry. He'll tell you a little bit more about himself as we get into it, but I'm very excited to have him impart his wisdom and answer all of your questions tonight. That said, we do very much want tonight to be interactive as much as you want to make it that. I do have some questions that were submitted when you all registered for the event, so I will chime in and ask those as we cover certain topics. I also want you to use the chat feature that you should see in your GoToMeeting control panel. You can either chat me privately, Lauren Oshman, or you can chat out to the group, and I will monitor that chat box and make sure that Tim we give Tim the opportunity to answer those questions. So with that, I will turn it over to Tim.
Thank you, Lauren. Thank you very much. It's an honor to be here with Vestia Wealth Management. And I agree, you not only need a good medical malpractice insurance policy, if you happen to be a dentist or a physician or a surgeon in today's litigious environment, but you also need the advice of the expert folks at Vestia Wealth Management to round out that circle of asset protection. And you need both, and I encourage you to give them a call. Likewise, for the medical malpractice part of it all, we can move to slide 2 if you want. I am officially the Vice President of Claims of Practice Protection Insurance and also Doctors Direct Insurance, which is a practice protection company. We provide medical malpractice insurance to physicians, surgeons, and dentists. And I have a little bit of experience in the medical malpractice world. In the insurance world, we call it medical professional liability insurance, MPL. In tort law, it's called medical malpractice. That's the actual tort. But I, in addition to being educated in biochemistry and zoology and not able to get a job, got into the claims world of medical malpractice and a long time ago and enjoyed it greatly. I have, the last 20 years or so, been a co-founder and president of 2 insurance companies, and I was retired for a very short period of time. And then Mike Wallace, who is the president and CEO of Practice Protection Insurance, called me up and asked if I would like to jump in and help them handle claims, which I truly enjoy. I've handled many thousands of medical malpractice claims. I've been involved in 1,000 mediations, dozens of trials, and hopefully have learned something along the way that I can impart to you folks tonight. Aristotle was correct. We don't like to be lectured to. We like to tell stories. I'll try not to digress too much, but I have a lot of stories, and they are to teach a point. And let's not hesitate to interrupt me. I don't mean to be just rambling on here on my own. It's more of a fireside chat. There's no fire, just a library. Please don't have a fire in my library. And but Lauren will be able to get the questions if you don't have a direct access to the questions. And I'll be happy to interrupt. I'm going to do 4 things here tonight. We're going to talk about the history of medical malpractice and how we got here. We're going to talk about the status of the current marketplace in medical malpractice. We're going to talk about the policy itself and the basics you need to address when you're looking at one. And then we're going to do a little bit of a dive into the anatomy of a lawsuit. And all of 4 of these things are essential, but I'm going to approach them from the 10,000 foot level. So if you want me to dive down into the weeds, just jump right in and I will be happy to do so. But if I did that for everything, we'd be here for hours, and you don't want to do that. And please feel free to, this is a very relaxed atmosphere. I happen to be drinking coffee on this end, so cheers, and let's get started. Next slide, please. Thank you. You probably didn't realize, I didn't until I started studying this, but the topic of accountability for iatrogenic injury, IATROGENIC, iatrogenic meaning physician caused or healthcare provider caused injury, goes all the way back to the Code of Hammurabi. I kid you not. And I wrote it down so I could read it to you. If the surgeon has made a deep incision in the body of a free man and has caused the man's death, or has opened the caruncle in the eye and so destroys the man's eye, they shall cut off his forehand. And you thought defensive medicine was a modern concept. This is 4,000 years ago. And who knows if they ever enforced this, obviously. Some king somewhere lost his eye and they put it in the code. But let's jump forward to the Oath of Hippocrates, 370 BC, first do no harm. And then let's jump all the way forward to the Revolutionary War of the United States. We are the only country, along with Canada, to have a contingency fee system in civil litigation. So if someone files a lawsuit and the attorney who represents them gets a percentage of the award, it's anywhere from 25 to 40% plus costs. And this all arose from 1776, when we did not have a navy as a young country rather. And we issued letters of marque and reprisal to the pirates. And the pirates then became our navy, and they became privateers. And they got 40% of the booty off the ship that they kept off of our shores. And today, the pirates wear suits. So this is where the contingency fee system comes from. In England, it's illegal. They call it champerty, and you have stepped over the line as a lawyer. You have ceased becoming the objective lawyer, and you have become the client, and that's not allowed in English law. It's called champerty and is illegal, but we do allow it here, and it does have many pluses and minuses. We could go on forever, but that's our system here in the United States. Next slide, please. Then let's jump on up to Illinois. In 1856, there was a case in Bloomington, Illinois, McLean County, after I think it was the Great Fire of 1855. And a man fell off his roof while fixing it, and he broke his hip, and it was repaired by 2 local surgeons. And he then sued those 2 surgeons for a brand new tort called medical malpractice. Now in law, you have civil and criminal. Get rid of the criminal, we're not talking about that. And then you have civil, and underneath it is, or are rather, contract and torts, not something you bake. It's disputes between human beings, a tort. And a new tort in 1856 was recognized by the courts, and it's called medical malpractice. It turns out in the closing argument, the defense attorney, tall guy, lanky, big hat, near Springfield, you might know who that might be, and he said that this man should be down on his knees before God and these 2 surgeons that he is alive and walking today, even though he had a leg length discrepancy. The defense won, and yes, Abraham Lincoln was the first med-mal defense attorney in the United States. You can win something with that knowledge, I'm not sure what. And then, and all the way up to 1975 is when the real tort crisis in medical malpractice started in the United States. And in 2 states, Indiana and California, the laws were changed by physicians. The 1975 Indiana Medical Malpractice Act really can thank Otis Bowen, MD, who was the governor of Indiana at the time. And he set up a system where there's only one amount of money per lawsuit, and that's it. You don't get any more, and you have to go through a panel of lawyers and doctors in order to get permission to file your lawsuit. Now, could you also file it if they said no? Yes, you can, but I don't know why in the world you would, because they will point out you don't have a case, here's why, it's not worth your time. These lawsuits are expensive to bring, so I don't know why some plaintiff's attorney would throw $100,000 or $150,000 at something that he has a less than 50% chance of winning. So that's the one in Indiana, and today it's a $500,000 primary coverage, and then a 1.25 million on top of that, which is the patient's compensation fund. Now, the key to all of that in Indiana is that if you buy the primary coverage and the excess with the patient compensation fund, then you are immune above that from personal prosecution. This is a great deal. This is a good night's sleep for physicians, dentists, and surgeons to know in Indiana. The other one was in California. It's called the MICRA Act, the Medical Injury Compensation Recovery Act. And that was actually advanced by Dr. Anderson, who was the very long time CEO and chairman of the Doctors Company. And it was passed in 76, and it finally survived all the appeals in 86, and then went into play. And they get to essentially the same place. The premiums aren't quite as low as Indiana, but they're close. And it does many different things. It doesn't restrict, like Indiana does, the total amount of recovery, but it says, for example, all settlements will be in annuities. If you got $1 million in a workers' comp case, you can tell that to the jury, he's already got $1 million. Or you can't do that in the other states. Or as the award or settlement goes up, the plaintiff's attorney's share of it goes down. So putting all these things together and a few others, they came up with a system that is still viable today, and it results in lower premiums. So let's go to the next slide and see what pops up. We've talked about the history. We've talked about how we got to today's litigious environment. And today it is about the same frequency of lawsuits, but the severity is going through the roof. There are more verdicts in excess of $25 million than there ever have been in the system now. And we're moving from an abnormally long period of a soft market where premiums have been going down for a very long time. I don't quote me on this, but I think it's about 12 years. Normally it's a sine curve like anything else dealing with human beings. And so it's 4 years down on the curve and then 4 years back up to the same price again. So generally speaking, over say a 50-year period. But we are now at the bottom of that trough, and the premiums are coming up. And it's a combination of factors. Like I said, the number of verdicts that are very large are drastically increasing. We could talk about the reasons for all of that. One of it is social inflation, for example. You can win $1 million with a scratch off lottery ticket. So what the heck? Let's give them $1 million. Or there's anger at the system, and some people regard it as a lottery. The jurors, when polled, will tell you, they told the pollsters that 42% of them said they will do what they believe is fair and ignore the law. So courts are a little unpredictable, and that's the problem. But when you have verdicts going through the roof like that, then settlements rise, because reasonable insurance companies and reasonable claims people don't want to go to the courtroom to resolve cases. In my own career, I've probably been involved in 12 cases that involve brain damage to children, and those all went to trial as very defensible. 11 of them were won by the defense, and the 12th one was lost for so much money it wiped out all the savings of the prior 11. So it's a gamble when you go into a courtroom. You're having a group of 12 people, usually 6 in some states, but 12, who their only qualification is a driver's license. I usually tell physicians, when Walmart opens their doors, go stand next to the greeter. The first 12 people in are your jury. And that's a little scary, because you're going to try to teach them medicine and dentistry and surgery, and which are almost always very complicated. They did try all physician juries. I think it was in Nevada, either there or Arizona. I'm pretty sure it was Nevada. It was back in the 50s. And it didn't work because they couldn't get 12 physicians to take out 2 or 3 weeks of their life and sit in a jury pool. That's the only reason it didn't work. But interestingly, there were far fewer verdicts. But when there was a verdict, it was a whopper. They really penalized the defendant. But
I did have a question, Tim, that came in with the registrations, just asking like high-level stats for percentage of doctors that would be sued sometime over the course of their career, and if you had any idea of, percentage of cases that maybe are settled versus dismissed or go to trial, just some of the basic stats. I don't know if you know those things off the top of your head.
Well, let's get real generic. 5% of the physicians generate 60% of the losses. So it's like any group. 5% of any group is not there for the purpose of the group. So it's no different in medical malpractice. 5% of the physicians, surgeons, dentists generate 60% of the losses. Now, of those, it depends on your venue and your specialty. If you're a cardiac surgeon in downtown Miami, you're going to get sued about once every 3 years. If you're a dentist in a similar environment, it might be once every 30 years. But if you're a small town physician and you're the only physician in town in Southern Illinois, you're not going to get sued very often because they love you and they want you to stay, even if you make a mistake. It depends on a lot of factors. But basically, 50% of all lawsuits are due to communication errors between human beings. And 30% of the lawsuits are due to systems errors, which we thought were greatly going to be improved by computers, but it's only made matters incredibly worse. And 20% are actually clinical malpractice. So really 80% of the lawsuits that are filed should be able to be not repeated if we can learn from their behaviors and learn from the system improvements that need to be in place. 20%, I can't do anything about. You need further education. You need further CMEs, or I mean, I've run into a lot of different cases. There was one man in Fort Lauderdale who was a fabulous diagnostician, but every time he got a scope in his hand, he punctured something. I mean, he just had bad hands. So We said we would insure you, but not for the scope procedures. He just quit doing the scope procedures and he never got sued again. So I mean, there are things that can be tuned in, but basically 80% of these cases are won by the defense, and 20% are lost for increasingly large numbers. That's the problem. But generally speaking, the cases are so much better now in their defense than they were when I started. OBGYN cases of newborn babies with difficulties. Those are much better to defend now than they were because the science is so much better. The same thing with anesthesiologists. They now have many assisting bells and whistles, if you will, on the machines that monitor as well as the human monitoring things. And so I forget the exact drop, but they've dropped from a class 6 down to a class 3. So very expensive down to modestly expensive. But if you're, we get into this with underwriting and in the policy, but the higher risk specialties will pay more premium and they will get sued more often. It just goes with the territory. I don't say this often, but I was taught a very long time ago by a plaintiff's attorney in Philadelphia that there are 3 elements to a medical malpractice lawsuit, and they are in order of importance: damages, coverage, and liability. You find me the first 2, and I'll find the third. That's a scary statement, but in general, that's what plaintiff's attorneys are looking for. Almost all of them are very good people, don't get me wrong, but they're in it for the money. They're also helping people, but they're in it for the money. So they want high damages, large coverages, and then we'll find somebody to support our theory of liability. That's the way they look at a case. Now, a lot of cases come into the big firms. The extreme example would be in Boston, the lead med mal plaintiff firm in Boston. They have a retired surgeon and a retired trial lawyer who review every potential claim that comes into their law firm. They take 1 in 75. Now that's obviously an extreme, but so the cases that I'm seeing in the claims every day are all large cases in damage. There are no extended 3-day hospitalization due to something that happened in the hospital. Those cases don't get filed anymore. There are no broken leg cases. There are broken arm cases. There's not enough money in it because you have to hire experts, you got to take depositions, it's going to take years, and you need a case that has large damages as well as coverage to pursue. And that's why multiple people get sued usually, even though they may not be directly involved in the allegations of negligence. And that's why hospitals tend to get sued repeatedly, even on agency theories, even though they're not involved directly in the care, because or they'll be improper credentialing, improper something, didn't meet the criterion for a bariatric center, so they get sued for that. Because they usually have $10 million, $15 million, $25 million policies. And that is a target that plaintiffs' attorneys would like to get into. So long answer, yes, there are breakdowns by specialty, by venue, and a lot of, there's one physician that just comes to mind, I can't mention them, but they actually went out and hired a coach to teach them how to interact with humans better. And Albert Einstein Medical School has a new program now where they're accepting new students from other specialties than the sciences, because they figured out they were graduating physicians who had incredible scientific knowledge and they had absolutely no idea how to talk to another human being. So their bedside manner was terrible. They were just treating everybody like a specimen. And no wonder people didn't like them. The patients didn't like them. So there's more to practicing medicine than great medicine. It's an interaction with your patient as well. And that really helps a great deal in prevention of medical professional liability lawsuits. It's very subjective, but I think it's true. So where were we? We were talking about soft market going to a hard market. the problem is on many layers. The economy, investing money is not returning very much money in investments because insurance companies are limited to 15% of the money being in equities. The rest of it has to be in very, very low interest rate things that are liquid. And so it's hard to make as much money on the money you're saving for claims or you set aside for claims. And then number two, the reinsurance market, which is insurance for insurance companies. When we sell you $1 million policy, typically, the first $250,000 is the primary carrier's responsibility, and the next $750,000 is usually the excess carriers or the reinsurance carrier's responsibility. And that in turn is spread out, like in Lloyd's of London, to maybe 10, 12, 13 syndicates. So in essence, so there's a $10 million verdict in here, or nobody goes broke. It spreads out through the industry. But the Lloyd's of London people told me, for example, that they didn't include in their algorithms and set aside money for the fires in California. So all of a sudden they had to write checks for a whole lot of money, and they didn't have that in their calculations. So the industry at large for the entire insurance industry is at about 104% combined loss ratio. So you're not making any money. You're not even surviving. You're losing money. You're going to go out of business like this. So somebody has to raise premiums in order to succeed and be able to continue to offer the product. I've heard numbers as high as 135% for some of the syndicates at Lloyd's. So they in turn charge the insurance company higher premiums, and then the insurance company can only absorb so much of that and has to pass it on down. Hence, soft market to hard market, and add to that the claims exposures. The frequency is about the same, but the severity is increasing. So all of that is causing the premiums to increase. Sorry, I didn't mean to spend so much time on this. What's the next slide?
We did have a question just asking if there were any changes in premiums that were directly, maybe this was someone who was observing some of that increase in premium, if any of that was directly related to COVID and added risks that come with that.
Not in the world of medical malpractice. This is my opinion. This has not been tested in the courts in any way. But I put the COVID-19 cases alongside the MRSA cases, the methicillin-resistant Staphylococcus aureus cases. People come down with MRSA, and then they start suing somebody back up the chain here. And it usually is a suit against a doctor or a hospital for failing to follow protocols or for failing to use the right antiseptic agent, on the room or something. None of them succeed because of causation. We're a little ahead of ourselves, but anyway, here we go. There are 4 things you have to have in a tort to be successful. You have to have a duty that was breached either through an act of omission or commission that is causally related to a damage. So not temporally related. And you don't know where the COVID came from. That's the point. You can't nail down with a more likely than not answer where this COVID-19 came from, unless, of course, somebody totally deviated from the CDC protocols and just blatantly ignored everything. Then you may have a case. But I don't see anybody pursuing the MRSA cases. They do get filed sometimes, but they go away pretty quickly. They're usually filed by rookie attorneys. And I think the COVID exposure is the same thing. Follow the CDC protocols. Do everything you can to, be preventative. Encourage your people to get the vaccines. All these normal things, masks, social distancing, et cetera, and put it into your office or your clinic or your hospital. And I think you will have a viable defense. I can't prevent people from suing you, but I think this will give you the best defense possible. And then, of course, document what you have done. You can't just come through every day and do it and not write it down. That doesn't work in today's world. You have to document what you did today, and in some journal of, COVID-19 protection or whatever you can in your clinic. So does that help on the COVID-19? The question is, what are generally considered the highest risk specialties to insure? Oh, that's easy. Surgeons. If you spend your day walking around in someone else's brain, that's a very high risk thing to do every day. That's why these don't quote me on these numbers, but I mean, you could easily have a family physician at 8,000 and a neurosurgeon at 80,000 a year for the same coverage. Cardiac surgeons, orthopedic surgeons, neurosurgeons. I'm sure I'm leaving someone out, and I apologize. Plastic surgeons. These are the folks who have larger premiums. Now, that's for normal surgery. Sometimes with very high volume, you'll see an assembly line, in essence, of cataract removals or something, where one person will do one thing and the next doctor will do something else. And when you're doing 500, where most people do 100, that's a higher premium. But the lower risks surgery are dermatology, no surgery, family physician, no surgery, no hospital admissions, turn it over to the hospitalists. Pathology, dermatology, psychiatry, those are very low risk specialties. But everybody is buying essentially the same policy, but depending on your specialty and depending on where you're doing this, there's an article that comes out every year listing judicial hellholes. Cook County is always in it. Parts of St. Louis County and the surrounding counties are always in it. Houston seems to make it. Philadelphia and other venues seem to be regular players. But the juries are just more frequent and more generous in those venues than they are elsewhere. Atlanta has become a new one. Anyway, I hope I answered that question. What you want to look at in your insurance policy are several things. You need to decide what policy limit you want. Almost everybody in the United States buys $1 million policy, and that provides you $1 million worth of money for settlement or to cover an award from a jury, up to $1 million. Along with that comes our defense costs. In the insurance industry, we call it ALAE, or allocated loss adjustment expense. And this can be very expensive. This is why you don't want to go alone into a lawsuit without insurance. It is not unusual in Cook County to have a lawsuit last 3 years, 4 years, 5 years, and you're paying an attorney anywhere from $200 to $250 an hour all that time. It's very expensive. But with our policy, it's unlimited defense costs along with your limit. In Texas, they have $200,000 limits. That's a statutory minimum. In Florida, they have $250,000 statutory minimum. Some people buy the larger limits, especially say in an emergency room practice. There may be 20 people in an emergency room practice, and they will all buy $1 million limits, even though that state has a lower minimum limit requirement. That just happens to be the requirement of the hospital that is contracting with that group, and it's part of the contractual demand. Fine, if that's what you need, that's what we'll sell. And in addition to those two things, though, excuse me, we also offer a set amount of coverage, usually $25,000, sometimes $50,000, for licensure proceedings. If somebody files a complaint against your license, or you didn't do your CME requirements and the Board of Medicine sends you a nasty gram, it says, By the way, your prescription privileges for Medicaid and Medicare patients are now pulled until you finish your CMA requirements. We will represent you in that to the regulatory board, and they're all over the board. Usually they're minor matters. Sometimes you get a wrong site surgery, and the patient will sue, and that generates an automatic $10,000 fine and 20 hours of continuing medical education in medical records or in how to realize you're operating on the wrong side. It is interesting to me over the years that some of the finest surgeons I have ever met are on the wrong side club. That's what they call themselves. And it's just so easy to do. The gurney is 180 degrees from its usual position, or there is actual pathology on the place he operated on, as opposed to the other side where he was supposed to operate on. It's just so easy to do in this busy world of medicine today. But you need that coverage as well. And then on top of that, I want to emphasize risk management. We try to prevent the lawsuit from happening. If you can call us when there's some untoward event going on, we can advise you in a way that may help you avoid the lawsuit. You have to communicate with people. If there's an untoward event in a hospital, in a surgical suite, you, the surgeon, need to go talk to the family, not the nurse, not the hospital administrator. They may do that as well, but you have to go talk to the family. It makes all the difference in the world. And the same thing in your own office. Funny things come up where need help, or sometimes it's how to fire a patient. Last time I gave advice, I rattled off how to fire a patient with a return receipt letter, and the guy on the phone said, "She's homeless." I went, "Oh, well, that won't work." So we had to come up with something different on the spot. He wrote in the chart what he wanted to do, initialed it, she initialed it, and that was good enough for a homeless person. We couldn't really do any better than that. There are a lot of funny stories too, but the hostile 18-year-old in the waiting room of a dermatology clinic, and he was demanding to be seen immediately for an emergency. I asked the doctor, he was just getting more and more potentially violent, and because he was told to come back another day. And I asked the physician what the emergency was, and he said acne. And I said, "That's not an emergency." And he said, "I know that." So we decided that we would, the doctor told the patient that his issues were so complex that he needed to go up the street to the county hospital and seek additional, subspecialization for his very serious condition. And as soon as he got out the door, they locked the door and everything was fine. So I get all kinds of questions. The latest one was not a swallowed crown, but it was an inhaled crown. So the man had to go across the street, get a laryngoscopy to get the darn thing out. And anyway, we're going to pick up a few bills outside of insurance, and everything's fine. He doesn't sue the dentist that way. So we're here to help on risk management and lots of issues. And that is essential when you're looking for a good medical malpractice insurance company. And finally, I'm spending too much time on all this stuff. The policies today are consent policies. Excuse me. So the physician and dentist and surgeon have the right to give the final consent to settle a case. If you don't want it settled, you don't have to settle it. If I think it should be settled, we're going to have a conversation, and I will lay out the risks you're taking in not agreeing to some settlement. It does happen where we go to two different experts and there's no support for the liability. It's time to move forward and settle the case and quit paying lawyers. But I've seen this go back and forth over 40 plus years. It used to be that there was this provision did not agree, it was not contained rather in the policy, but now it's come back around, and in order to be competitive with other insurance companies, everybody has included it in their policy. So Next slide, please. What's this question?
Tim, we do have a question in the chat. It's kind of long, so I'll read it while you get yourself a drink. How stable is the med mal reform in Indiana moving forward? It's been under fire for some time, resulting in the more recent increase in caps. And why hasn't this reform migrated into other states over the 4 decades it's been enforced?
It's well funded. If you're asking about the viability of the patient's compensation fund, it is well funded. But as in all states, the defense and the physicians are up against the trial bar. And Lord, I hope not too many are listening, but trial attorneys on the plaintiff side are many things, but stupid is not one of them. They are very, very smart in how to work the legislatures and the laws in all states, some in particular better than others, to make sure that the environment is good for them in filing lawsuits. Illinois has sitting on Governor Pritzker's desk right now a bill that was passed at 3 o'clock in the morning, just before the whole thing was shut down, that gives, I think it's 9% prejudgment interest from the date of knowledge of the injury, not when the complaint was filed, but from when the doctor knew that there was an injury, the 9% starts running. And you thought lawsuits were expensive before? Holy cow! Start racking up 9% a year for 5 years on a $5 million award. The interest gets higher than the award pretty quickly here. So I haven't seen, by the way, prejudgment interest at 30 years, but Florida's a good example. Plaintiff attorneys will take some of their lesser talented on their feet, but very smart junior partners, and they'll get them elected to the legislature. And instead of being in the more famous committees that get you a lot of publicity, they'll be on the Judicial Selection Committee. They'll be on the Civil Rules and Procedure Committee. It's boring, but it is absolutely essential to how cases are tried in that state. And they also they're just very good at what they do. And we frankly need to, it's just my humble opinion, we need to get some very smart and savvy street smart physicians who are retired and elect them to the legislature. And let's counter these kinds of things. But to answer your question, the PCF is fine. It's well funded, but it is increasing because the value of cases are increasing and the value of services to a person who has suffered an iatrogenic injury is increasing. So there are some people who are truly injured, and the old, I don't know the current stats, but it used to be true that there were always 2 people a year, this is a rough estimation, 2 people a year who were injured by an iatrogenic manner, and there's not enough money in the statutes allotted to take care of them for their lifetime. So there's always a tug and pull argument going on in Indiana about how much that patient compensation fund should be. But basically, it's half the price of the underlying coverage is what it boils down to. And dentists, for sure, they're paying, just say, for example, they pay $800 for an underlying coverage, pay the other $400 and get the total, and you're immune from personal injury, personal exposure above that. So what's this question down here? Why is tail coverage so expensive?
Yes, this is why is tail coverage so expensive. I recently had to buy a policy to cover my tail, even though there were less than a dozen cases that were still under the 2-year statute of limitations. It was still crazy expensive, like $60,000.
Well, it depends on their specialty, for starters. And now we get into claims made versus occurrence. I think that's on the next slide. It used to be, I'll give you a little, if you're interested, this is getting into insurance geek speak, but a fire policy is an occurrence policy, you know, but for medical malpractice compensation, for I don't know, 70 years, 80 years, it was all occurrence policies. So the policy that's in effect is when the treatment was rendered. The problem with that is at the end of the year, you're the actuary inside the insurance company. You have to set aside an amount of money for all the cases that potentially have occurred that year, which you have no idea what it is. I mean, you don't know if they're going to get filed, if they have been filed, if so, how much they're worth. And it's a gigantic guess based on 10 plus years of actuarial data. And there's a much more precise way to do that, and that's to issue a claims made policy. So the policy that's in effect is when the claim is made against the doctor or the dentist or the surgeon. So the incident happened in July of 2018, and it got reported today. Then the policy for today, this annual policy today, is in effect. Why in the world would you want to do that? Because at the end of the year, you know exactly how many cases you have. You just don't know how much they're worth. So you come ask a guy like me who has a lot of experience, and I can tell you roughly how much these cases are worth. And so you can set aside money much more precisely at the end of that year. Now, the way to sell that to the physician population was the first 5 years of the claims made policy. It's a gradual increase in premiums. I forget, it's like 20% the first year and 35 the next, and then 60 and 80 and 100, something like that. But I'm not an underwriter. And so the amount of money you're essentially not paying that first year, or the first 5 years, is what you now need to pick up on the tail policy, because this is called an extended reporting period endorsement. And it turns your claims made policy into an occurrence policy. And to do that, it's roughly 2 times your annual premium. And then no matter when the lawsuit's filed, 10 years from now, as long as it happened between your retroactive date and the date you left the company, you're covered. So the occurrence policy is always more expensive. And if you're a dentist, buy the occurrence policy if you want. You're talking about numbers that aren't big of a difference between claims made and occurrence. It won't negatively affect your cash flow in your practice. But if you're a neurosurgeon, it makes a huge difference. So that there's a reason that tail policies are more expensive, because you're covering the entire policy of treatment, no matter when it comes in the door down the pike. And it's just expensive to do that.
Does the statute of limitations have any impact on the pricing? Because I think that's part of the question, is that there's only a 2-year statute of limitations and not much of the work that he'd done.
It depends on what state you're in. The 2-year statute of limitations from the date the plaintiff knew or should have known of the injury, that's true. It's a 4-year statute of repose. It's a 7-year statute of fraud. For licensure, there's no statute whatsoever. Never throw away your medical records, no matter what guys like me used to tell you 30 years ago. Throw them away after 10 years. But I've changed my tune on that. Don't ever throw them away. Digitize them. I don't care what. Just store them someplace. And by the way, if you're storing them in a unit, make sure you put them up on something in case there's a flood. I've seen all of that. So it covers more. It is a 2-year statute of limitations in most jurisdictions. But again, getting back to the original subject, the plaintiff's attorneys are constantly attacking the statute of limitations. And in commonwealths, for example, like Philadelphia or Virginia or Massachusetts, the statute of limitations is 21 years and 9 months. So you try to remember what you did 21 years and 9 months ago. I can't remember what I had for breakfast. So it is factored in, yes. The tail policies in Massachusetts are much more than they are in Indiana. But the statute of limitations is being watered down constantly, and it's not just 2 years.
And then we had a question, someone entered this when they registered. Is it worth it to pay extra for that occurrence-based coverage, or is it better to just buy the tail coverage if you leave?
The question is conflicting in its question. You have to, if
you had a choice between occurrence and claims made, which one is better?
If I were a dentist and it was just me, I would choose the occurrence policy. But because then you won't have to worry about the tail policy later. You won't have to worry about, it gets messy sometimes. I mean, sometimes the corporation pays it for whom you're working. Sometimes you pay it. Somebody forgets to pay it. You lose your coverage. I mean, it's just easier to buy the occurrence coverage. It's a good night's sleep. You know it's in place. You paid your annual premium. And again, with dentistry, you get sued once every 30 years. So, I mean, it's just not that big of a number compared to your overall clinic. But if you're a physician, by the way, in Practice Protection Insurance Company, the first year of coverage with us for a new dentist coming out of school is free. We give it to you for nothing. So I think that's a great thing for somebody to latch onto. But either one is fine. Either one works just well. Just when you leave a claims-made policy, you either buy the tail, the extended reporting period endorsement, or you go to the next carrier and make sure that your retroactive date, the date this started over here, it doesn't start when you left, but goes all the way back to the beginning. This is kind of geeky. I didn't mean to get into all this. This is down in the weeds. But you have to make sure, sometimes it's less expensive to just go with the next carrier, like Practice Protection, and then we would pick up your coverage just like it is, and probably at a lower premium, but we would cover you for all acts from your retroactive date forward. Go ahead. Did that help?
I think so. We actually had a lot of questions about tail. So that was a popular topic. Okay. Someone did ask, I've heard the cost of tail may be negotiable. Is that true? Maybe that's part of what you're talking about.
I am not aware of that, unless, no.
Maybe it's just that shopping it around, kind of looking at the options, right? You could buy the tail policy, or you could do like you're talking about and look at an alternative to pick up prior acts.
If you're with one of the very large insurance companies, they will quote you a price for tail. And then you can come over to Practice Protection, and we will quote what is known as a standalone tail policy. It's standalone extended reporting period endorsement. So even if you're not practicing, or you're moving out of state or something, and you just need the tail coverage, you don't need any more insurance where you are right now, we can quote you a price that is usually lower. We average, a good percentage lower. Like I think it's 20, 21, 22% lower than the marketplace. So it would be known as a standalone tail policy. So yes, it is negotiable between companies. Yes.
Perfect. Shall I go to the next slide?
I think we exhausted this. Let's go on. Let's get into something that's more conducive to a little interest. This is underwriting. We've already covered all of this. The pricing factors. We've covered the 4 elements of a tort. And I want to make sure you understand that. There has to have been a duty that was breached, omission or commission, that is causally related to the damages. Now let's go on to the next. I have notes in front of me here, which I have totally abandoned. The anatomy of a lawsuit. I've been involved in a great number of lawsuits, and frankly, I don't know anybody in the United States that has more experience than I do, but there are many of us who have the same amount of experience. It's a fairly limited fraternity. But this is what really causes indigestion and ruins people's lives, is when they get named in a lawsuit, and it shouldn't, but it does. One of the things I've mentioned in here, I'll jump ahead, is 5 stages of grief. I've figured this out. These are the Kubler-Ross stages of grief. I'm talking about denial, and then anger, and depression, acceptance, and resolution, roughly. Don't quote me, I'm not a psychiatrist. But I found the depressed physician to be just the worst witness on the planet. They tend to agree with the questioner in order to get the deposition over with. And I've seen just some awful things happen in a deposition with a depressed physician. And I just want you to know that it will be normal for you to go through the 5 stages of grief when someone who you thought was a part of your clinical family, a patient, sues you for malpractice. And they show up in my office. Denial got left at the curb. They'd do it exactly the same way again. They show up in my office angry. They throwing complaints up against the wall, screaming things at me like, what am I supposed to do? Biopsy every lymph node that walks in the office? And you're going to receive a summons, which is the first page summoning you to the courthouse, and a complaint, which are the rest of the pages that indicate the allegations of negligence being directed against you. It will look like you are one of the worst human beings on the planet. Do not take it to heart. It's just a plaintiff attorney laying out allegations of negligence. In some states, they have to include, like in Illinois, they have to include an affidavit from the attorney who's filing it that says, I have spoken with an expert witness. Here is what the witness says, but they don't have to identify who it is yet. And then the process server will show up at your front door, or show up at your clinic, or mail it to you with return receipt. There are lots of great law school stories about process serving. And if you're flying over Arizona and the guy next to you is from Arizona and you hand him the process, is that good? Anyway, the answer is no. I want you to know you will get a summons and complaint. Do not call the plaintiff's attorney and tell him what you think of him. Do not alter your medical records. We could sit here for the next 3 hours and talk about medical record stories. Today, it's even worse with the digital recordings. Whatever keystroke you make is recorded somewhere in the system, and the plaintiff's attorney will find it. In the old days, it was non-computer. I've seen recreation of medical records. One medical record was sent out to another plaintiff's attorney before this lawsuit arrived. And when this one arrived, the physician sat down and recreated the entire medical record. Sat up, used different pens, different papers. It was beautifully done, actually, but it was a complete fraud. And I'm working away at my desk, and I get this blank envelope in the mail, and I recognize the name of the patient, and I get the other one out, and I'm looking at exact same dates and totally different treatment regimens. And you lose this lawsuit. I don't even care what the facts are. Whatever defense you had just went out the window. If you need to add something to the lawsuit, first of all, ask your attorney or ask me, ask someone inside the claims management of your company, and then pull out a fresh piece of paper or the digital equivalent thereof, put today's date on it, and then talk away all you want. Try not to be critical of others. Try to be objective. But do not alter this medical record in any way, shape, or form. It will come back to haunt you, and you will lose the case based on that rather than on something more substantive. So your first thing you do is notify your medical malpractice insurance carrier and then we retain counsel on your behalf. We know who the best attorneys are. Let us hire the best lawyer who's experienced and successful in medical malpractice defense. I do not need to hear about your divorce lawyer. I do not need to hear about your cousin who just got out of law school. I know this is your reputation as well as your asset protection that Vestia is going to help you with, and we're going to help you defend. So the first thing you'll do is meet with your attorney. You'll go over all the specifics. You and I will probably have already had a deep conversation on the phone. And then we will exchange. There will be a formal answer filed by your attorney denying all the allegations. And then we'll do interrogatories, which are just basic facts going back and forth. Who are you? Where do you live? And so forth. And then we move into depositions. And they will depose the parties and the subsequent treating physicians and the experts, and then you get to decide whether or not you want to go to trial. You may know within 90 days if you want to settle this case. You should know within 90 days, maybe 120. But we're going to get the medical records, we're going to get them reviewed, and if that person's critical, we go to the second expert. If that person's critical, you and I need to sit down and have a conversation, because it may be time to settle this case early, or it may be time to gear up and defend it. I have a story to tell you about depositions as soon as I have a sip of coffee. Thank you. Let's just say it's your turn to be deposed. You get to the plaintiff's attorney's office. The very nice receptionist greets you in a very nice lobby, march you down a little hall to a conference room, big mahogany table, leather chairs, beautiful Persian rug, floor to ceiling windows looking out over the park, looking out over the water. Court reporter sitting over here, the other attorneys yucking it up about the NFL game last weekend in the background over here. Your attorney sitting next to you. The plaintiff's attorney is engaging you in conversation about your kids, about soccer games. This is all on purpose. This is all something to get you to relax, to not have your guard up. And then in the case that dealt with a damaged child's brain due to hypoglycemia treatment, the next question was, court reporter, are we on the record? Yes. Good. So, doctor, tell me, are there any other symptoms and diaphoresis for the hypoglycemia that killed this child's brain? The answer to that question, the first half of that question, is yes. There are other symptoms and diaphoresis for hypoglycemia. The answer to that second half of the question is no. I don't agree that the hypoglycemia had anything to do with this injury. Most people without proper education as to how to give a deposition will answer yes to that question. And if you do, we're done. You lost. Just get your checkbook out. And that, welcome to the world of lawyers and depositions. You may be the smartest person in that room, but this is not your element. Lawyers use words like bullets, and you're getting shot down out of the sky here. You do not win a case at deposition. You survive a deposition. Do not think that you are smarter than that guy, even though you probably are. But don't go in like that. And in this case, the physician had enough sense to say, you know, I'm just a poor old country doctor. You know, could you break that down for me? And everybody in the room on the defense side took a breath, a sigh of relief. And the plaintiff's attorney smiled and looked at the other attorneys, and he went back to asking questions on the regular medical record. But I'm just warning you ahead of time, just don't be overconfident in this arena. And it's all being written. Very few of them are videotaped. although we're doing a lot of them by Zoom these days. And I don't know about that technicality. I'll have to ask. But you don't have to answer the question immediately. It's being written down. Somebody will read this. If there's a 40-second pause in between the question and the answer, nobody will know. It's being read. And if you don't know the answer, the phrase "I don't know" is okay. Or I can't believe how many physicians I've seen make stuff up because they don't know the answer. Or don't fall for the doctor, didn't you just say, and then they re-summarize your testimony in a way that's more favorable to their case, and they look at you and go, right? And you say, no, that's not what I said. Let's go back over it again. So the other tricks are numerous. There will be a pregnant pause, and then they'll just kind of look at you and kind of raise their eyebrows, and most people will start talking to fill in the gap. Don't do that. Just sit there and smile at him. It'll drive him nuts. So this is a deposition, and then after the depositions come mediations. Next slide, please. Mediations and then a trial. Now, mediations are very prevalent in our industry. There are some really good mediators. There's some really awful mediators. They're just an 8th grader could do the same thing. They just go back and forth between the parties, relaying numbers. That's not what a mediator does. But you will show up again at a mediator's office or the plaintiff's attorney's office. It's usually a mediator's office. These days they're being done by Zoom. But I didn't realize until the last year how much I relied on reading the room. I read people very well, and I didn't realize how much I was relying on that skill because in Zoom you can't read anybody. You can read one person in front of you, like Lauren over here smiling. She must be liking this. Anyway, but no one else is available to me to look at. So you'll show up. It'll be a rainy day, probably. It'll be lousy. There'll be people in the mediation room, as we say in medicine, they're suits with briefcases. But you will probably be brought into a main room first, where everybody will be. You, your lawyer, your insurance representative, that would be me, by the way, and then the same thing for the 2 other defendants in the hospital. And then at the last second, in comes the plaintiff's attorney with the referring plaintiff's attorney, who gets 25% of the plaintiff's attorney's commission or fee, by the way. That's not written down anywhere, but that's what happens. And the plaintiff. Now, they've been trying lately on me to not have the plaintiff there, and I refuse. Because this is the chance for the defense to say, I'm sorry for your loss, but, and then explain our side of the case. It's the first time that plaintiff really has ever heard it, because her attorney or his attorney is not going to tell them all the bad things about their case or the positive things about the opponent's case, because he doesn't want him or her to go to another attorney across the street and this guy loses out on his fee. So the mediator will come in. There's a lot of gamesmanship that goes on when you get down to places like Miami. Plaintiff's attorneys will sometimes be purposefully late, wearing the big sunglasses and the big double-breasted coat. Anyway, they make an entrance and they think that's cool. It's different in every venue, but you will get a chance to say something if you want. If your defense attorney will let you, I recommend no. I recommend you don't say anything at all, and then you'll listen to each presentation, and then you'll all break out into rooms individually. Sometimes the defense stays together if it's a cohesive defense, but usually you have to break out. And then the mediator now earns his dollars. He goes to the plaintiffs and says, you're going to lose the case because of X, Y, Z. You can't defend it. You know, you're never going to win this allegation. And so lower your demand. And then he'll go across to the defense and do it in reverse. Your defense is not going to work on A, B, and C, and you need to put some money on the table. By the way, it's going to cost you $150,000 to try this case. Come on, put some money on the table. And they'll work it back and forth for hours. And if the closer you get to 5 o'clock in the afternoon, the faster the money moves. It's funny how that works with human beings. But eventually you'll get to the points where it's either settlement or impasse. And that's all that comes out of a mediation. The rest of it's written on the wind. Settlement or impasse. And sometimes you have to get creative. Sometimes you have to pay a lot of money. Sometimes you say no and just say no. I'll see you in the courtroom. We didn't do anything wrong. But you will go through the mediation process, and it is worthwhile. It's irritating. It's lengthy. It'll wear you out, but it is worth the time, especially if you want to get a reasonable mediator. Usually they're retired judges. They're the best because they've seen it all. And they can work both sides to get to something that's reasonable. If that doesn't work, and lately I've seen 2 or 3 mediations in each case. The last one I did, I negotiated for 8 hours, and they went from $1 million down to $975. And I said, "Have a nice day." In that case, it was so ridiculous. It was in Chicago. I just looked at him and said, "Until you get under $500,000, I don't want to talk to you." And so he kind of exploded a little on that, but commented on my heritage, but that's okay. But you have to confront the folks who are used to getting higher numbers even if they don't have a case. But if that doesn't work, then you're off to trial. And by the way, I just noticed, I have not noticed this before, that our general counsel, Saunders Bliss, was the one who put the pictures on this slide, and I noticed that Mr. Bean is down there on the driver's license. He's right. The only juror qualification is a driver's license. As I said, go stand in the Walmart entranceway when they open the doors, and the first 12 people are your jury. It's rough. Our system of juries is irritating, lengthy, expensive, and without a doubt the best system on earth today. It really is. They usually find the right answer. Not always. I have stories, but it's going to take you a long time to be involved in a trial. It'll take you a week of preparation. You have to read all the depositions. You have to read all the expert witness depositions. You have to meet with your attorney many times. You have to be ready for any kind of question that can come to you. Review your own deposition over and over. You will be cross-examined on that thing, and if you disagree with it in one word, you're going to get hammered in the courtroom and made to look like a fool. You have to be very, very well prepared. And on top of that, it's going to take you at least 2 weeks. The last major trial I saw was it involved 2 neurosurgeons, hospitalists, and a hospital. And it settled on the 3rd week of trial. They had just finished motions in limine and picking a jury. 3 weeks. They haven't even gotten to the opening statements yet. So it can be just enormously expensive, which your insurance company is paying for, full defense costs, but it takes away from your practice of medicine. You can say goodbye to the practice of medicine for a long time if you have to go to a trial. And what's next here, Lauren? I think
you're getting close to the end.
Hey, how about that? Everybody's saying, "Oh gosh, finally." I just wanted to say, really, I wanted to thank Vestia for this opportunity. We could dive down into any of these subjects at a great deal more length if you wanted to, but you need a twofold approach. You need a good insurance company, and Practice Protection Insurance, Doctors Direct Insurance, provides you with a competitive premium, provides you with excellent customer service, an experienced risk management team, but also an experienced claims management team who hires nothing but the best attorneys. And we also welcome your contact, so we can show you how we excel in our field. But I know that Vestia welcomes your contact as well. I don't know how Lauren wants you to contact her or others, but I cannot say enough good things about Vestia. They are fine people who will represent you well and handle your finances well and protect them as well as the law allows and the systems allow, and you will be in good hands. And you need both. I talked to a physician only a couple of years ago in Ormond Beach, and he was so pleased that he had a $250,000 policy and a $15 million Schwab account. I said, dude, you have a $15,250,000 insurance policy is what that is, because you got no protections. And he talked to the likes of Vestia and was able to change that and protect all of his hard-earned assets. You work hard, you deserve to have it protected. And thank you very much for allowing me in to your home this evening. Lauren.
Thank you, Tim. We did have one other question that didn't come up, asking about whether there were any extra steps that doctors should be taking if they're doing a lot of telemedicine in this current environment of COVID-19, just from a protection standpoint.
Two different questions. I don't know what telemedicine has to do with COVID-19 in particular, but we cover.
I think they're doing more virtual clinics, whereas they may, like I've seen my doctor twice, in the last year, just like this.
I was thinking.
I always go to the doctor.
COVID with telemedicine, that doesn't make any sense. Okay.
Yeah, no.
We cover telemedicine. It is common. It is completely covered as if it were an office visit. So there's nothing different as far as medical professional liability is concerned. Almost all the cases I'm aware of will be filed where the physician sits, it is just a common practice today. Pediatricians have been doing this for 50, 60, 70 years. There are entire books written on pediatric medicine by phone. And we cover telemedicine. I don't see any real concerns. Just make sure you send, when somebody needs an emergency room, they need to go to an emergency room. When someone needs to go to a lab, they can go to a lab. There are things you can do from afar on a phone that you don't have to do in a physician's office. But as far as we're concerned, it's the same coverage. There are no limitations on coverage.
Perfect. That is all the questions that I got in advance. I think we've covered the questions in the chat. So you can see on your screen, if you want to get in touch with Practice Protection, that's Tim's company. You can see on the screen how to do that. If you want to talk with Vestia, you can email us at myteam@vestia.com, and we can get you in touch with one of our advisors to talk about protection and coordinating you with a really good asset protection attorney outside of your medical malpractice coverage. So we can hang out for a couple minutes if there are any more questions. Otherwise, thank you so much for your time. Thank you, Tim, for your time and expertise. And I hope you all have a great night.
Thank you, Lauren.